Appearance.
May it please, my lord. My name is Stella.
Yes.
My lord, I'm holding the brief of CN Fabio for the judgment credit.
Okay. Yes, defendant. Defendant.
My lord, Emma Okebu. My lord, due respect, Emma Okebu.
Yes.
Well, I appear for a judgment debtor.
Okay.
Well, we're having problems hearing the court very well. I don't know why.
Oh, you can't hear me?
Yeah, sometimes it goes over, sometimes it comes back.
I think it's the Please mute it. Is it on? Mute your microphone. Since you're in open court, it's only for you to turn on your mic.
Can you hear me now?
Yes, my lord, I'm hearing you. I'm hearing you, my lord. I'm hearing my lord now.
You can just switch your phones off. Maybe it's the interruptions bouncing on my own.
My lord,
I'm hearing you,
my lord is okay. He's okay now, my lord.
All right, beautiful. Yes, appearance.
May I please, my lord?
Yes, I'm taking Umar Okegbo for judgment debtor.
Ask up, please.
Yes.
May I please, my lord? I am E and I am Mrs.
Yes.
My humble appearance is for the Ganishi, Zenith Bank PLC.
Okay. Yes. Any other?
If you please, my lord.
Yes.
Respectfully, my lord. My
Yes.
name is A.C. Okora.
Yes.
I humbly appear for the third party applicant. Michael Okpara, Uni Greek Microfinance Bank.
All right. I believe there's a pending ruling.
The matter is ruling, my lord.
Okay, I'll go to it shortly. I have to get it from my computer. Just a minute. Just a minute. I'm getting the document shortly. Just a minute. Okay. This is Onyendi. It's here. All right. Try to get the document page so that we can all participate and we read along as I read. Has it come up now? Can you see the document?
Yes, my lord.
Oh, beautiful. All right. Okay. Well, ruling. If you can read, you can read along. At least it will not. It will keep you active in the proceeding. There are two interlocutory applications to be determined in this fresh garnishee proceeding initiated against the garnishee bank here, Zenith Bank PLC, by this judgment creditor via a subsequent ex parte application filed on the 29th of January 2021 in a bid to secure the payment of the alleged outstanding balance of the judgment sum of 31,460,609 naira 51 kobo. A decree order nisi was granted in consequence of this subsequent application on the 3rd of February 2021 by this court. This garnishee bank was ordered to appear before this court to show cause why the order nisi should not be made absolute against it. The judgment debtors were also placed on notice in accordance with the rules of this court. On the 19th of February 2021, the garnishee bank filed its affidavit of cause and deposed, particularly in its paragraphs 8 and 9, that account numbers 10138788974 and 10141942251, which were attached to the order nisi, did not belong to the first judgment debtor, Michael Okpara University of Agriculture, Mudike, but to Michael Okpara Uni-Agric Microfinance Bank Limited, which is accordingly not a judgment debtor in the original judgment of the 14th of July 2015. As such, the Michael Okpara Uni-Agric Microfinance Bank Limited, or MOU-FMB, henceforth, filed a motion for leave to appear as a third party in this suit, as well as seeking an order to vacate the decree order nisi granted, which accordingly attached their bank accounts in the custody of the garnishee bank. The third party intervener first filed for this via an application on the 1st of March 2021 by its initial counsel, Emmanuel Tochukwu-Chime, Esquire, but subsequently replaced by another application filed by its new counsel, A.C. Okorafor Esquire, on the 6th of July 2021. The former application was thus struck out with the leave of this court on the 1st of March 2021. This means the first application to be considered in this ruling is the third party applicant's motion of the 6th of July 2021. Meanwhile, on the 3rd of March 2021, the first judgment debtor filed an affidavit deposed to by one Agha Michael and attached two exhibits as well as a written address franked by Ima E. Ukaibu. This is the second interlocutory application up for consideration by this court. On the 11th of November 2021, the respective counsel to the parties moved, adopted, and orally argued their concerns in these applications in open court, whereupon the matter was adjourned to today for this ruling. Prior to moving their respective applications, the third party interested party was immediately granted leave to be joined as a party in this suit to enable it acquire the necessary locus to prosecute its application legally. As such, the first limb of its application of the 6th of July 2021 has already been granted. Before proceeding to evaluate both applications before this court, I wish to observe suo that this subsequent garnishee was erroneously initiated and filed with the same suit number as the first garnishee proceedings, which was concluded by the ruling made on the 10th of November 2020. Excuse me, it should be noted that this current garnishee action is separate from the previous one in which part payment of the judgment creditor's entire judgment sum was successfully garnished against another bank, which is First Bank of Nigeria Limited. That suit number was NICN OW5M 2020, and the sum of 5,614,948 naira 87 kobo was laboriously and eventually recovered from the First Bank Limited in a tight contest, not dissimilar to this action now before this court. This current action is for the recovery of the sum of 31,460,609 naira 51 kobo. It is indeed a separate suit from the first one, and it goes without saying that it was grossly an inadvertence or fault of the registry of this court to have retained the same suit number as the first action. Being an irregularity, however, it does not affect the substance of the action, and so it shall be ignored for now, particularly since none of the parties drew any attention to the anomaly. I shall start by evaluating and resolving the second application, which was raised by the first judgment debtor first, because it was filed prior that of the third party intervener. The first judgment debtor noticeably did not file any motion or notice, but an affidavit on the 3rd of March 2021, which is titled Affidavit of Agha Michael in respect of the enrolled order NISI made on the 3rd of February 2021 in respect of the judgment debtors. Learned counsel to the first judgment debtor had in open court adopted the written arguments which accompanied the affidavit and made an oral submission for the court to consider the affidavit so as to determine whether or not the decree order NISI should be set aside. It stated that the first judgment debtor is not foreclosed at this stage from convincing the court to refuse to make the order NISI absolute. Now, relying on the 13-paragraph affidavit deposed to by Agha Michael, an administrative assistant in the service of the first judgment debtor, and two exhibits lettered A and B, the learned Ukaibu stated that this affidavit is predicated on two grounds as contained in the written submissions, which are that the judgment creditor had since the 11th of November 2016 been recalled by the varsity to resume work, but he had refused to collect his recall letter and commence work, and that the judgment sum claimed by him is in excess of the actual amount owed him based on the judgment of this court made on the 14th of July 2015. In his written submission, learned counsel maintained that the judgment creditor obtained the order NISI by fraud or deceit, and the court granted same without being in the picture of the true facts. Accordingly, he refused to avail the courts with the fact that he was formally recalled to duty by the first judgment debtor by letter dated the 11th of November 2016, which letter he rebuffed to date. According to counsel, if the judgment creditor had resumed duty following the letter of recall exhibit A since 2016, any outstanding salaries would have been paid, thus avoiding the necessity for filing this garnishee proceeding. Accordingly, also, the judgment creditor's outstanding salaries are as contained in exhibit B, which is accordingly 6,296,371 naira 35 kobo. In his oral adumbration, learned counsel stated that this figure is an admission by the first judgment debtor, and so the amount of over 37 million naira claimed by the judgment creditor is unjustifiable and untrue. They say 37 million naira was falsely computed, and so counsel finally urged the court to refuse to be used for the unjust enrichment of the judgment creditor. In response, the judgment creditor merely remarked that he is not in receipt of the affidavit in question, and so he had not filed any counter affidavit against the facts stated therein. He also did not offer any legal arguments against the submissions made by the counsel to the first judgment debtor, even though he had the opportunity to have done so on the 11th of November 2021, when the arguments were raised. This court, however, sieved through its file to ascertain that not only was the affidavit of the 3rd of March 2021 served on the judgment creditor, but that nothing was filed by way of a counter affidavit against the judgment debtor's affidavit. This may not have been discovered soon enough by the learned CM Okpabio, who had taken over the matter from the erstwhile counsel representing the judgment creditor from the 1st of April 2021. Whatever the circumstance occasioning this default was, this court is not allowed to speculate on facts and evidence not before it. Saliently, this court is not and should not be a court of speculation. You may see Kim Davis, military governor of Angola, citations supplied. It means in effect that the contents of the judgment debtor's affidavit, if unchallenged by the judgment creditor, must certainly weigh against the judgment creditor, since it is safe for this court to countenance the constituent facts in the said affidavit as having been admitted by a silent adversary. You may see Alege versus Abimbola, citation supplied. The judgment creditor owes the onus of proving that the balance of the judgment sum, the subject matter of this garnishi, is in excess of 37 million naira, and that he was never recalled by the judgment debtor in 2016 following the judgment of this court in 2015. The law is notably trite that it is on the vulnerable party to lead credible evidence in proof of his case. You may see Honor Buchere versus Esegene and other cases cited, citations supplied. Now, rummaging through the single exhibit, which is the judgment of this court delivered on the 14th of July 2015 by Anwe J, attached to the exhibit expert motion of the 29th of January 2021, which presaged the grant of the decree order nisi of the 3rd of February 2021, the court had specifically granted the following orders on page 20. Thus, A declaration is made to the effect that the dismissal of the claimant from the employment of the first defendant was unlawful, illegal, null, and void, and hereby set aside. B, the first defendant is ordered to forthwith reinstate the claimant to his employment. C, the first defendant is further ordered to pay to the claimant all his outstanding salaries, allowances, and other emoluments accruing to him from the date of his unlawful dismissal from his employment, which is the 8th March 2013, till the date of this judgment, which is the 14th of July 2015. D, the orders made in B and C above must be complied with within 30 days from the date of this judgment, and if not paid within the period, the sums shall attract 10% per annum until paid. In the ex parte application, the orders sought were an order to attach the sum of 31,460,909 naira 51 kobo, being the balance of the judgment sum in suit number NICN/EN/132/2013, due to the judgment creditor against the judgment debtors from their accounts with Zenith Bank PLC numbers -- and an order directing the garnishi to appear and show cause why the order nisi should not be made absolute against them for the said sum of 31.4 million naira. It would have been presumed that had the first judgment debtor not challenged that sum above, the court would have no reason to refute the correctness of it, despite that the actual judgments never mention any exact figure representing the real amount of money adjudged to be paid to the judgment creditor. The judgment creditor neither exhibited how the judgment sum was calculated, nor provided any records to show his entitlements within the periods the judgment debtors were ordered to pay him from March 2013 to July 2015. I have no reason to disbelieve the first judgment debtor's affidavits in this regard, that the judgment creditor had been asked to resume work in the varsity since 2016, based on Exhibit A attached to the affidavit, and that the total amount owed him, based on the judgment of 2015, is only 6.2 million naira and not 31.4 million naira, in the absence of any superior evidence to the contrary, as seen in Exhibit B of the affidavit of 3/3/2021. Having thus been paid the sum of 5.6 million naira already by the order of this court granted previously on the 10th of November 2020 in the previous garnishi, the supposed balance based on the first judgment debtor's admission should be 681,422 naira 48 kobo only. Therefore, I have every rational reason to concur with the first judgment debtor applicant here that the judgment creditor inveigled this court into obtaining the decree order nisi that was granted on the 3rd of February 2021, and I so hold. Although this court can make an order substituting the said 681,422 naira 48 kobo instead of 31.4 million naira, as the subject of this garnishi proceeding, apparently in the interest of doing justice and for expediency of this action, yet I find it unsafe so to do because the initial claim put up is not for the lesser sum, and the court cannot impose on parties what they must litigate upon. Besides, as stated previously, having repeated the old suit number in this action, the implication is that the garnishee process is a continuation of the previous one, wherein a decree order absolute was made and the matter finally concluded. This subsequent garnishee action should have been filed with a separate suit number, and so it will be ill-advised to merely substitute a sum claimed with a lesser amount while retaining the same suit number. Consequently, the application on behalf of the first judgment debtor succeeds, and the decree order nisi of the 3rd of February 2021 should and is hereby vacated. Now, on the premise of the above finding, therefore, the third party's application, which similarly seeks for the vacation of the said decree order nisi on the ground that the accounts attached by this court do not belong to the first judgment debtor, requires no further deliberation, as same has become merely academic. The action has already been declared to be incompetent, and so it follows that nothing can be maintained against them in this action without the necessity to further waste valuable resources to examine and consider the questions raised by the third party intervener here. The court hereby sets aside the order against the accounts held by the Garnishee Bank and discharges the Garnishee Zenith Bank PLC, including the third party intervener, MOUF MFB, from this proceeding, and I so declare. The third party applicant may, however, refer to this court's previous ruling on the 10th of November 2020 in suit number NICN OW/5M/2020 with respect to a similar application made therein in order to appreciate the reasoning of this court on the issues raised by him here. By way of ancillary order, the judgment creditor is hereby ordered to either receive the letter of recall supposedly written since the 11th of November 2016, if he has not done so already, and resume full work within 7 days of this ruling, or in default be deemed to have forfeited his employment contract with the first judgment debtor indubitably. An employee should only be paid for work done, as the courts will not be used for the purpose of unjust enrichment. In keeping, however, with the 2015 judgment of this court, which is still valid and subsisting, the first judgment debtor is still bound to pay the balance of all entitlements owed the judgment creditor from March 2013 to July 2015. Ruling is made accordingly, no costs awarded.
Hello, we are grateful.
That is all.
Thank you, my Lord. We are very grateful.
You're welcome. You'll get a copy of. Thank you. Thank you.
Lord, we are grateful for the well-considered ruling.
You're welcome. You'll get a copy of it immediately after proceedings. Judgment creditor to. You're welcome. So that will be all. On the next.
Suit number NICN/OW/49/2019 between Professor Makesta Onyamejiodo and Federal University of Agriculture, Umudike, and another.
The last for the day.
Yes, ma'am.
The claimant is online. It's online. If I can see him. Defendant?
My Lord, we're online.
Okay. Yes, online, also online. Yes, appearance?
My Lord, with respect, the Mao Cable.
Yes.
I appear for the defendant.
Counsel. Is the claimant counsel present?
Yes, I've spoken with him this morning online.
Okay. Yes.
Please, my Lord. My Lord, I'm present.
Where are you? Claimant Counsel.
My Lord, I'm present.
Where are you? Okay, yes, enter appearance, please. You may enter appearance.
Lord, that's not okay. No.
Okay, Kanu.
Yes, my Lord. I appear for the claimants, my Lord.
Please switch off your phone. Yes. What's the case for?
My Lord, the matter is for continuation of hearing and the cross-examination of the claimants, CW1.
That is the cross-examination of CW1.
Of CW1, my Lord. My Lord, before that, the ACBs furnished me by the clerk of the court. I don't know the particular number, the PhD degree of the claimant, the number, my Lord.
Come on, check.
PhD degree. Not there. Not among
Was it tendered by you?
Yes, my Lord, we did.
If it was tendered, we'll find out. But before then, defendant, are you ready to cross-examine? Is the defendant ready to cross-examine the witness?
Yes, my Lord, I'm ready.
All right. I hope your questions are not very long.
My Lord, there is there. There.
No, you're only entitled to 40 minutes.
My Lord, let me start. My Lord, 40 minutes won't be enough, but let me start.
No, 40 minutes is okay for you. 40
Lord,
minutes.
Given the
Our rules does not say if you are online, you should extend it. It says only 40 minutes. Have you seen it?
No, they have not tendered the
I don't think you have tendered any certificates.
17 documents.
No, my Lord, it was part of the documents we tendered when the claimant appeared in person. Yes, my Lord. The only reason why it was not accepted was that the defendant's counsel said he didn't have a copy of it. And subsequently, he had told me he has seen it.
Okay. Well,
yes, sir.
It was never tendered before us.
But, my Lord, it was part of the package.
It was loaded.
It was front-loaded, my Lord.
They front-loaded the documents, the statement of facts.
No, my Lord, it was part of our additional written deposition.
Is there doubt that he ever acquired such status?
My Lord, I don't think there should be, but to be very, very precautious because I don't know where the defendants are going to come from. It's not in doubt, my Lord.
Wait. Okay. Where was it obtained? Which university? The certificate?
My Lord, that was sorry, let me. Lord, that was a Nova Southeastern University. Nova South.
They are breaking.
University. Sorry.
I don't think we have any.
The certificate was obtained.
I don't think we have anything like that so far. Is it in the reply or in the reply? Your network is so bad. Mr. Khan, the network is very bad.
It is. My Lord, it is very, very bad.
Yeah.
It is very bad. I accept, my lord. Since morning, that's been very bad. That's been very bad.
Quite unfortunate. Anyway, we don't have any such documents front-loaded in our file. Mr. Okay, would you have a copy of that document he's talking about?
He sent me a copy, my lord.
Or he sent you a copy, but it's not front-loaded in ours.
Yes, my lord.
This is the reply. This is
My lord, I can furnish the court. It's not in contention.
The
I
claimant
can furnish the court.
decree.
The document is not in contention at all.
Okay, when it's time, whenever you're in court, you can do so. Then we'll consider what weight to attach to it.
That's copy.
If necessary. So, Mr. Okay.
My lord.
My lord, I didn't report on this. Sorry, sir. Sorry, sir. I didn't get a position of the court.
Whenever you come to court,
This
you can
particular
bring the document. You can bring that document you're talking about whenever you're in court. Did you hear me? All right. Is the document pleaded in your pleadings? No problem, Mr. Kano's network. Would you be, is it convenient for us to continue, or do you want to, what do you want us to do? Since you can't join us, we can't hear you.
Yes, my lord, it's pleaded. It's pleaded.
Oh, so bad. Really, really bad. So should we continue?
It's up to him, my lord. I'm ready.
I can't, he has to be ready as well. Apparently he's not.
Yes, my lord, it's not.
I don't know whether that would affect him in any way if we continued with the cross-examination.
Of course, my lord, it will affect him. He has to hear the questions and take down and the answers too.
Claimant, the claimant is in court. Do you have anything to say?
Sorry, my lord.
Yes, okay.
Sorry, my lord.
Your
Yes, my
network
lord. I'm back.
so bad. We can't even
So
see
sorry
your,
about it. So sorry about it.
I can't even see your image. I can't even see you. Your video is off. Remember, this is a court proceeding. It's supposed to be like the normal, open, public court proceeding. But I can't see you. I can only hear you, and then even when I hear you, it's very bad. Yes, Mr. Kano, I can see you, barely make you out now. Why are you in the dark? Can we proceed with the cross-examination?
My lord, the audio is bad. I can't.
Once again, lawyers have to invest in getting better equipment. These days, getting a very good phone is no longer a luxury. It's a necessity. I suspect your phone is not as good.
I'm not using phone this time.
Are you using?
My lord, this time I'm not using phone. I'm using compact laptop, my lord.
Go and buy Apple. Go and buy Apple. for 3 million naira or 4 million.
My lord, I'll come to you for loan.
No. You have clients. You have small clients. Just call your client, tell him to give you one. Anyway, are you ready now?
My lord, if the network will agree me, I want to go on with the matter.
Okay.
But only that it fluctuates.
All
Yes,
right. Mr. Okebo has 40 minutes to cross-examine.
I thought my lord said 45 minutes.
No, sorry, sir, but I didn't hear.
40 minutes.
Sorry.
If I was to grant 5 minutes, that would be...
Sorry, my lord, I didn't.
Yes.
Sorry, sir, I didn't. My Lord, I didn't hear what my Lord said regarding that certificate.
I said when you come to court, the next time you come to court,
Sorry, sir.
you can bring the documents.
Yes, sir.
And
Ask
then
God,
you
please.
show,
I'll
you
do
show us where you pleaded it. If you pleaded it,
Ask
I'll
God,
allow you to
please.
get it. But if you
I'll
do
do
not
that, my Lord.
plead it,
Within the week.
all right.
It's pleaded. It's pleaded. my Lord.
That will be the next adjourned date. Whenever you come in court in the next adjourned date, you can bring that document. Now, Mr. Okegbu.
Yes, my Lord.
40 minutes.
My Lord, let's confirm that the witness is following us.
Are you there, witness? You have to come back to light. Mr. Manchester. Good, you have to turn on your light. You're enjoying the sunlight in Miami-Dade.
I'm not hearing him.
Yeah, no, you have to unmute your microphone too.
I've done that, my Lord. I'm
talking of the witness. Aha, good.
Okay.
Can you hear us now?
Exactly. I'm fine.
We need to see your face. We need to see your face, whether it's you or somebody else.
That's me.
It's you. Are we sure?
Yes, sir. Yes, sir. It's me.
Well, if the lawyer is satisfied, okay, but you satisfied? If you are free, you can continue. Let's try it and see.
As my Lord pleases. Mr. Manchester.
All right.
Yes.
You admit that you never did transfer of service from Nnamdi Azikiwe University to Michael Akpara University when you were employed.
Yes.
You admit that you never did transfer of service?
Transfer of service.
Yes, because, can I explain why?
To Michael Akpara
University. You have to explain later, yes.
Oh, okay.
Don't interrupt, Mr. Okay.
Ask God, please.
Transfer of service from where? From where to where?
From Nnamdi Azikiwe University.
Okay, yes.
To Michael Akpara University.
And the answer is yes.
Yes, my Lord.
Can I explain about that?
You were employed at Mike.
My Lord, he wants to explain.
What's there to explain? He has answered the question.
No, I have to explain, sir.
Let him explain. Please.
Okay, I resigned from Nnamdi Azikiwe, and when you resign, if I had wanted the transfer, they may not have approved it because they needed me so bad in the department. I resigned. I made up my mind to resign. So when you resign your appointment, what other thing do they want from me to do a transfer? Because they needed me so urgently.
I have your record that I resigned from Nnamdi Azikiwe University.
Exactly. That's it.
Voluntarily. Yes, next question.
Under the conditions of employment in Michael Akpara University, is there anywhere that is authorized that when you resign from your previous place of work, you will not do your transfer of service? Are you aware of any such?
I'm not aware of such. Where the point is, what I know is that when you resign your appointment, it means that your appointment has ended.
Can you clarify the question, Mr. Okay, what was the question? Under the conditions of employment in MOUA, yes?
There is no authority that if he's resigned from where he's coming from, he will not provide his transfer of service, he will not transfer his service.
Okay. There's nothing precluding you from producing your records of transfer from another university.
Yeah, well, that can be done anytime.
Okay.
The authorities at Michael Akpara University requested for a transfer of service in writing from you.
Okay, I was very busy. I didn't have time.
Please answer my question.
What do you mean? The authorities requested for records of your transfer of service?
Transfer of service, yes, my Lord.
Is that true?
I don't recall when I was specifically asked to get a transfer of service.
Yes.
I want to put it to you that you were specifically in writing requested to furnish the transfer of service from Nandazgo University, and you never did that up till today.
Okay, like as I said before, I may not have done that, but that can be done at any time. There's no time limit.
Yes.
Yes, my lord. You also admit that before you filed this suit, you did not appeal to the authorities, the vice chancellor, the council, the visitor. You didn't appeal to them before you filed, any of them before you filed the suit.
The answer is correct, but I'll explain why. Because the letter demoting my rank never gave me any chance for appeal. There was no written request for anyone to appeal his case. It was not there.
Now, do you mean appealing to the governing council of the university?
Exactly. There was no indication on the letter that if you are not satisfied with this decision, you should appeal. So how am I supposed to know?
All right. Yes.
Have you ever seen the law setting up the university?
Have I ever done what?
Have you ever seen the law setting up Michael Obama University?
No, I have not.
You have not.
Yes.
When you were employed, you were given the condition of service for senior staff.
Yes.
Yes.
Actually, excuse me. No. The only thing I was given when I was employed was a temporary letter of employment. That was it. Nothing was given to me.
Yes.
I want to put it to you that when you were employed, as is customary in Michael Obama University, you were given the conditions of service for senior staff.
That is not correct, sir. The book or the book called Condition of Service was given almost 3 to 4 years after my employment. And I'm sure my attorney has a copy. I actually gave him that paper. I mean, the book.
So you were not given immediately?
No, I was not given.
Yes.
Now, you said you are aware that the visitor to the university set up a special fact-finding committee at a point in the university.
What do you mean by that?
That is what you said in your document. In your
You said what? He stated that what?
He is aware that the visitor to university set up a special fact-finding committee.
Please, why don't you refer him to that particular paragraph?
Please stop. It's not your turn to say anything. Let's
no banterings. Well, can you show us where you read it so we can go straight to it?
Well, my lord, I said when I was going through, because I didn't know you My Lord, yeah, let him say it. Let him answer.
Anyway,
I said,
I'm sure he can answer. Now, are
Yes.
you aware? Are you aware that the university set up the visitor of the university?
I said, my
set
Lord,
up-
my question is, he said,
Okay, all right. Did you say that the visitor of the university set up a special fact-finding body?
Your Honor, I can't recall specifically saying that. Several committees were set up in the university, starting from when, when the committee was set up in the university, that was not the visitors. Several committees were set up. I don't recall specifically saying that the visitor set up a committee. I don't recall specifically saying that, because
yes,
I was never informed of any visitor being called in the university.
okay. In any case, if he said so, the document is there and we can read it at any time. It will speak
Exactly.
for itself.
Exactly, Your Honor.
Yes, next question.
yes, sir. I'm sorry, sir.
It's all right.
Now, after you were elevated to a professor, was
Yes.
there a committee at any time set up by the visitor to the university? Your knowledge?
I'm not aware.
You're not aware.
If there is one, I was never officially informed.
I am not aware, or I was not aware.
I was not aware of that, Your Honor.
All right. Yes.
No, not your honor, please. My lord. Only
It's
my
all
lord,
right.
not your honor.
He's in the United States. They call judge.
Okay, I'm sorry.
It's okay.
My apologies.
I have no concerns about that. So you can call me on
Ask God, please.
or Mr. Galadima if you want. It's all right.
Okay.
Ask God, please.
Yes.
Thank you, my lord. Yes, my lord.
Yes.
Now, in paragraph 4 of what you call a further reply to the claimant,
Yes.
in paragraph 4, you gave the defendants notice to produce some documents.
Yes.
One of those documents is letter of visitor setting up special fact-finding committee.
Yes.
The second letter, is letter to the, you asked that a letter of the visitor setting up a special fact-finding committee you produced.
Yes.
You did that.
And what was the question?
I said, is he aware of that letter?
Are you aware of such letter?
Letter I'm not aware of that. If there is a letter, maybe somebody has forwarded letter to my attorney, but I'm not aware of that.
Yes.
You also asked the defendant to produce minutes of meeting and report of appointments promotion committee recommending staff audit with biometrics.
Report of meetings.
submit
Which paragraph? Paragraph what?
paragraph 4.
Paragraph 4. Okay.
4, sub 5. Minutes of meeting and reports of appointment and promotion committee recommending staff audit with biometrics and certificate verification.
Yes.
So you are aware of that report?
I'm aware of entire university staff verification, which everyone did, where I submitted all my documents, appointment letters, my degrees. I have 3 degrees, and everything the university wanted, I submitted everything just like everybody else, and that's the only what I know about. It was the entire exercise in the university.
It wasn't, okay.
Yes.
You also asked the defendant to produce minutes of meeting of council and resolution for constitution of subcommittee of appointment and promotions committee. My lord, that's subparagraph 6.
Subparagraph 6.
4.6, yes, my lord. 4 subparagraph 6.
In the reply.
Of his, no, he filed something, yes, for that reply. For that reply.
Yes.
In subparagraph 4, in paragraph 4, subparagraph 6. I the defendant use minutes of meeting of council and resolution for constitution of subcommittee of appointment and promotion committee on staff audit and proper placement.
Yes, what's the answer?
That request may have been made through my attorney.
You are aware of the minutes?
I'm not aware of the minutes, but I'm aware of the requests.
You are aware of the request, all right.
That's good.
Yes.
Yes, my lord. Now, you said you submitted, there was a program in the university where you submitted all your credentials or certificates and all that. When was that?
Quite frankly with you, I don't have the dates with me here. If you want, I think the university can also furnish you that.
Yes. Do you know the year?
Do you know the year?
I'm assuming, I think probably between 2016, 2017, or 15, 16, or 17, something like that.
Okay, so between, let's say, 2015 to 2017.
Yeah.
All right. I don't know the precise date, but it may have been between 2015 to 2017.
Exactly.
And that was after your elevation to the post of professor.
Yeah, it's a program that has been ongoing in the university and is by college or faculty by faculty.
The one you submitted your certificates and all your credentials was after your elevation to the post of professor.
I should suppose so.
I suppose so, yes.
You submitted those certificates and credentials to which committee?
Okay, the university has, I'm not sure if it's a committee. There are people that were selected to do that exercise, and it is by college or faculty by faculty. So where it was our own faculty did in a different day and other faculties did in a different day. So I am not sure if there's a committee specifically set up for that, but I knew people were designated to carry out the exercise.
You're not sure of a standing committee?
No,
If
I'm not sure of that.
Yes.
So you are aware that the entire staff of the university were audited?
Yes, I'm aware.
What was the question, Mr. Okegbo? Whether the entire staff of the
You are aware
university?
that the entire staff of the university was audited by that process?
Well, I will not tell you every staff was audited, but it was a policy that for me, I'm sure of my own and my department. I'm not sure about everybody else.
Yes.
You also aware that that process was conducted by the Appointments and Promotions Committee?
Lord, the network has
Question
not been
again.
fair to me, on and off on my side.
Mr. Kanu, yes. Do you have an observation?
Do I
You
go on,
said
my
your network is not good, Mr. Kanu. Okay, yes, you may proceed. 20 minutes has gone already anyway.
My Lord, I'm not following. The network has been on and off.
You'll get the, we have the
Outside.
record, you have the record on my in my record book. So you can read it later.
Yes, my Lord.
You can get you a certified true copy of my record after the trial. Then if you have any questions under re-examination, you may do so. Yes, the next question. Okay, yes.
My Lord, my question is, my Lord, these interjections. My question is, he is aware that that process was carried out by the Appointments and Promotions Committee of Michael O'Brien University.
I'm not aware of that. I'm not aware that that exercise was carried out by the Appointment and Promotion Committee. No. And there was no document to me as a senior staff indicating that.
Yes.
Yes. And you also aware that process was after the visitor set up the special fact-finding committee. It was
That is not true.
Results, right?
That is not true. The general audit has been going on in the university way before anything else, before our issue came up. So I don't think is what you are referring to.
Lord, sorry,
Yes.
Lord, I've not been following.
The last question asked by the council was that
me out. Lord, I can't hear you.
Yeah, your network is very poor.
My Lord, do I go on?
Yes, I think you should.
Now, apart from submitting your documents, credentials, certificates, you also appeared before that committee.
That is correct. Well, look, don't tell me
Lord, I'm not
committee anymore. Just say, did you appear for the exercise?
You won't tell me what to say. You won't tell me what to say. Answer the question.
Okay, because you said the committee, I appeared for the exercise. That's all I know.
For the exercise, good. That's
Lord,
all.
I'm not following. Lord, I'm not following.
Kanu, once again, you will get a copy. You will get a copy of what transpired today. And if you have any questions under re-examination, you can do so. Or if you have any objections to any questions, you can raise them subsequently. There's nothing else we can do.
Lord, I'm also entitled to raise objections.
Of course, you are.
Yes, I have the right to raise them.
Nobody.
Yes, sir.
Nobody.
And I cannot do it based on the network issue.
So what do you want us to do now? Make a suggestion. I'm listening. Yes, Mr. Kanu. What do you want us to do? Can you listen to me? Can you?
Lord,
Can you
I don't know. Well, I've not been following. I've not been following. The network has been very bad on my own side.
what do you want us to do? Do you want us to adjourn the matter today?
Please,
Because
I
you're not
think we
following.
should continue. Let that happen later on, please. I think we should continue because this have been lingering for too long. Please.
Okay, Kanu, so far we've been having a smooth
Exactly.
cross-examination. I don't see anything wrong. And if there's anything amiss, I'll be the first person to raise it. So far, there is nothing wrong. And I told you, you'll get a certified true copy of the record of proceedings. Can you hear me?
My Lord, what of where I need to raise objection? I heard you, my Lord.
If there's need to raise an objection, it will only be to questions that are scandalous or embarrassing in nature.
Lord,
That's the only time you're allowed to raise objection anyway.
Okay.
But so far, so good.
Ask God, please. My Lord, we can proceed, my Lord.
Okay, you've just added another 5 minutes to his time. Yes?
It was after that exercise that you and others were properly placed by the university.
Which exercise? No, that is not true.
The exercise, you said you appeared and submitted your credentials.
No, that is not true. That exercise was done way before that. That is not part of it. That exercise was independent of what happened in the university. That was not part of it.
Yes.
I want to put it to you that it was after that exercise that you and others were properly placed.
That is not true. Exercise was even done before. That was not even the first exercise. Exercise was done even a year or 2 years before this very one. This exercise was the second exercise. That was not even the first one. So it has nothing to do with that.
Yes. Next question.
You are aware that proper placement of staff in the university is a regular thing done after each of those exercises.
As far as I know, proper placement is only possible during when people are, that is, when you come into the university. Can I explain that to you, my judge, please?
Yes, go ahead, yes.
Yeah, proper placement is only when you come into the university as a temporary worker. You have 12 calendar months to be regularized. That is the rule.
What you're saying is that it is only applicable to temporary employees.
Exactly. So then after you are regularized, then you continue. That's not part of it. Okay. When I came into the university, I was regularized within 1 year, which the regulation said.
Yes.
Now, you came into university as a temporary staff.
That is correct, because the vice chancellors are allowed to hire people then pending regularization, which is when they are actually interviewed, especially if a department is in need of a staff.
Yes.
My Lord, this witness takes so much time to answer questions. I don't think that time should be.
All right, don't worry. I'm looking at it. Don't worry.
Instead of answering the question, you're just telling us.
Go ahead, sir.
I know how many minutes. I know how many minutes you have. I know how many I'll add on.
My Lord, he even takes more time than myself.
You're supposed to stop. Ordinarily, they're supposed to stop at 11:35, I believe. But I've granted you some leeway, so don't worry.
As my Lord pleases. You were employed on temporary appointments in Michael Okpara on the 7th of January, by letter dated 7th of January 2013 as a senior lecturer.
That is correct.
Yes.
You were elevated to another professor by a letter dated 8th of September 2014 to take effect from 1st of October 2014.
Okay, that is, I presume so.
With effect from 1st September 2014.
Yes, letter was dated 8th of September
Yes.
2014.
2014
Take
to-
effect from 1st of October 2014.
yes, and the answer is yes, I suppose so.
Yeah.
Yes.
That elevation was based on your earlier letter of appointment.
Yes.
Can you explain to me what you mean by?
In other words, you were elevated from lecturer, from a senior lecturer to an associate professor.
Yes.
The question was, you are elevated from senior lecturer
To associate professor.
to assistant professor.
No, associate professor.
Associate professor.
Associate.
Yeah,
Associate.
professor. That is correct.
Associate professor, and the answer is yes.
Yes, my lord. Very good, sir.
Yeah.
Yes, you may. Yes, you may.
Now, by your own admission, when one is employed temporarily, when one is given a temporary appointment,
Yeah.
yes, my lord. When one is given a temporary appointment,
Yes.
according to you, he has to be regularized with when one is given a temporary, which is always temporary appointments. Sorry, temporary appointments always for 12 months. You agree with me?
Mm-hmm. Yeah.
Is that right?
That is
Yes.
correct.
You also agree with me that when you're given temporary appointment, it has to be regularized within the 12 months period.
That is correct.
Yes.
Yes, sir. Your regularization, you know, so you also admit that by the terms, by the conditions of service university, if it is not done within that period, it becomes invalid. Any such regulation becomes invalid.
I suppose so.
All right.
Well, that may also depend on circumstances because.
You've answered my question, please.
Okay.
Give your tantrums.
He said, I suppose so.
Yes, sir.
Yes.
Yes, sir. Now, you were appointed by letter of 7th of January 2013, given a temporary appointment.
You are appointed by letter of appointment on in 2013.
7th of January 2013, my lord.
Mm-hmm. Yes.
And that letter made it clear that your appointment will automatically, I'm using the language using that letter of temporary appointment, said your appointment will automatically cease after 1 year if it is not regularized, after 12 months if it's not regularized.
Mm.
Is that right?
What is your question then? That's not a question.
You said the document says that the appointment will be automatically
Terminate, the appointment terminates.
terminated.
If it is not regularized. within 12 months.
I suppose that's what the rule says.
So
Yes.
so that's what is in your letter of appointment, letter of temporary appointment.
Okay.
Did it?
Well, the document speaks for itself. We'll
Yes.
look at
My lord
Yes.
is material, so it has to come in, my lord.
Okay. Yes. He
Yes, sir.
said, I suppose so. Yes.
Now, you were the regularization came. Your own regularization was done on the 5th of September, 2014.
Was done 5th,
On the 5th of September, 2014.
2014. What's the answer?
Yes, but let me explain.
What is there to explain? That's when you
No,
were
no, I
regularized.
have to explain. I have to explain.
Yes, with an explanation. What's your
Good.
simple explanation?
The reason why that's the date that you are quoting is because my my regularization came with application for an upgrade. Now, again, like as I told you, when you are being regularized, that is when you do your
My lord, the question is
no,
simple.
that is correct.
Yes.
Now,
I
Very
have to
simple.
explain.
I have
You
your
don't have to
answer.
explain.
Yes, witness, I have your answers.
Yes, my lord.
Yes, with an explanation. The reason is because my regularization came with an application for upgrade.
Exactly.
That's your answer.
Yes.
Yes.
Yes, my lord. I want to put it to you that at the time you were purportedly regularized, the appointment was purportedly regularized, there was no subsisting appointment that it had automatically terminated. You had no appointment, there was no appointment to regularize. I'm putting it to you that at the time you were purportedly regularized, the appointment was purportedly regularized, the temporary appointment was purportedly regularized. There was no appointment to be regularized, and you had ceased to be a staff of the university.
Yes.
That is very, very incorrect. Application for regularization was announced in the university, and everyone who was on a temporary appointment was applied. And my application was made almost 6-7 months before the expiration of that time. But for the fact that I was applying for an upgrade, no, let me explain. If you don't, I won't answer your question again. So you let me explain. The issue is because I applied for an upgrade for associate professor.
Witness, yes. Now I have it correctly as saying that the question he asks is incorrect. My application for an upgrade was made about 6 or 7 months before the time of the regularization of the
Exactly.
Yes, my lord. Thank you, my lord. Now, you became a professor. You were made a professor in 2015.
Yes.
You became a professor in 2015, yes.
Yes, my lord. Yes, my lord. 31st from 31st of January 2015.
31st January 2015. And the answer is yes.
No, I'm sorry, sir. From 14th of October 2015. I'm very sorry.
14th
From
October.
14th October 2015.
Yes.
Is that correct?
To be quite okay, I have my appointment letter here. It said, okay, that is a confirmation of appointment to the rank of a professor of computer science. And that letter was dated October 14, 2015.
That's what I just said.
Okay. I just want to make sure.
Confirmation, yes. Confirmation letter is dated 14th October 2015.
Yes.
Yes, ma'am. Now, you remember that by a letter which you front-loaded, dated of 8th of September 2014, you were appointed an associate professor. by letter dated 8 September 2014, you were appointed as a professor from 1st October 2014.
Appoint you as associate professor with effect
from 1st October 2014.
1st October 2014.
Okay.
Now, do you recall that your letter of 8 September 2014 appoints you as associate professor with effect from the 1st October 2014?
I should suppose so.
I suppose so. Yes.
By another letter, which you also front-loaded, dated 15th October 2015.
Letter.
Another letter,
Yes.
which you front-loaded, dated 15th October 2015.
Yes.
You were again appointed as a professor from 31st January 2015.
Again, appointed you as associate professor.
Associate professor.
The issue
from which date?
2015.
From 31st
of January 2015.
2015. Yes.
That may have been so, but I suppose it is because after confirmation, after regularization, there must be a letter of regularization, and if you are appointed, there must be a letter of appointment. So I didn't write the letter. I think that should be in the personnel department. If you have any questions,
I agree. You didn't write it. That's what that's why we are pointing them out. So
yes.
Now, the letter appointing you or elevating you to a professor was dated 14th October 2015, while the letter elevating you to an associate professor was dated 15th October 2015.
All right, let me get the question again. The letter elevating you to professor is dated
14th October 2015.
Yes, whereas
the other letter elevating him to associate professor was dated 15th October 2015. Those are all front-loaded, my lord.
It's dated 15th October
2015.
Now, what in essence it means is that on the 14th of October 2015, you were elevated to professor.
Professor.
Then on the 15th of October 2015, you are demoted to associate
professor.
Associate
professor. Yes, my lord.
That's what it means.
That's my lord. That's exactly what we're going to show, my lord.
like as I said.
And those letters are all in the vault of my lord.
They're all tendered, you said.
Yes.
Yes, I saw they were given to me, so I want to believe they were tendered.
Can you explain the contradiction there?
Like as I said, my lord, one is when you are confirmed, you are giving a confirmation letter.
Yes.
And the confirmation letter will also have the rank that you have at that time. And when you are regularized, you're also given a regularization letter with the rank that you are. And if you are promoted at the same time, when you are regularized, a letter will also be issued. I think that is a question that they should ask the personnel, not me.
Hello, do I go on?
Hold on. I think, according to him, I think the personnel, or you mean the admin?
Yeah, exactly.
I'm sure that there was something fishy about his professorship. As a professorship.
No. You mean the admin should be questioned as to such anomaly?
That's what he said, madam.
If any, yes.
Bearing all these anomalies.
Yes.
It is that you rose.
You have 5 minutes left. Yes.
That you rose from senior lecturer in 2013. That is in January 2013.
Senior lecturer in 2013.
Rose from senior lecturer in 2013 to a professor in 2015.
Yes.
That is
Is that correct?
okay. I suppose so,
Am I
but
right? Am I right?
but no. Let me explain why.
I want to explain. Answer first, then you can explain. Am I right that you were elevated? You rose from a senior lecturer in 2013 to a professor in 2015.
I suppose so, because I was qualified. I have everything what it takes to get there. Because can I add something there?
Yes, go ahead. Yes, I'm listening.
Okay. Usually, when you are
My Lord, he has answered my question. He has told his
if
story.
you have all the qualifications, if you have the paper publications, you'll be elevated. And again,
My Lord,
when
the
the university, wait, when the university advertised for a job, advertised for a job worldwide, there's nothing in the book that should stop me from applying, and I applied, and I was duly screened, and I was selected. What is the problem?
It's okay.
Okay. Now, that is correct, because I was qualified. I am qualified to have applied.
You are qualified. Yeah, besides qualified.
Job.
Yes.
Yes.
Now you are aware that in Michael University, for one to be elevated from one position to the other, he must have stayed 3 years in the subsisting position. You are aware of that?
Yes, I'm aware, but there are two ways of promotion. There are two ways of elevation in the civil service of Nigeria. One is by regular promotion. The other one is by appointment. Unfortunately for me, I fell into the appointment one, which you know that the university advertised for a job worldwide. So I was not promoted. That is a wrong nomenclature. I was appointed, and appointment is another way of elevation.
So what you're saying is that by appointment, and the second is by
appointment.
Yes, appointment, and the second by what?
By promotion.
By
regular promotion, which is every 3 years.
All right. Yes.
Yes, my lord. Now, that letter appointing you to show you that you're not telling the truth, the letter that limited you from senior lecturer to rank of professor, that letter referred to your former position of senior lecturer. That letter made reference to your former position of senior lecturer. The letter elevating you from senior lecturer to associate professor made reference to your position as a senior lecturer.
My Lord, I think,
is that correct? Is that correct?
Sorry, my Lord.
Do you understand the question? Yes, Mr. Okay.
No. Yes, my Lord. My Lord, it would have been tidier if my learned friend is referring to exhibits before my Lord. It would have been tidier. Yes, not just saying letter.
No.
You know what I'm
speaking about, but I'm sure the witness can actually answer.
I'm sure that what I'm doing is even better than saying exhibit. I'm referring to a specific letter which he has.
Okay.
Nobody needs to be a rocket scientist to know what it's referring to. Now, that letter which appointed you from senior lecturer to professor made reference to your previous position as senior lecturer. Is that true?
As a senior lecturer.
That is not true. First of all, there's no letter appointed me from a senior lecturer to professor. Each stage has a letter. When I was given a senior lecturer, a letter was, I have an appointment letter. When I was elevated to associate professor, I was also given a letter. And when I was elevated to professor, I was also given a letter. So I don't know what you're referring to.
All right.
So if there is a problem with issuing the letter, I think it is the personnel department that's supposed to be consulted, not me.
Yes. Finally,
Again, my Lord, with due respect, look at how much time it takes to answer questions. My Lord cannot blame me for that. Now,
finally,
again, the letter the letter elevated you from associate professor to a professor. Made reference to your former rank of associate professor.
How will he know? The letter is not before him.
You pleaded it. You pleaded it. They are there. You pleaded it. I'm looking at your letter.
what was the question?
Which document? Which exhibit?
Okay,
The
Mr.
document.
Sorry, my lord.
You can't banter words. If you have
Sorry, sir. Sorry. I'm
any
so sorry.
observation,
I'm so
you have
sorry,
to
my
tell
lord.
the court directly. Yes.
My lord, I'm so sorry. I'm
Mr.
so
Okebo.
sorry.
Yes, my lord.
Now, the question you ask is whether the letter of appointment from associate prof to professor.
To professor. That is, to professor. Mentioned his former position as associate professor. To his knowledge. He front-loaded them.
Can I answer the question, please?
Yes.
I think you should have been aware that on each of the stage, from associate professor to
Answer
full
my question.
professor,
Then you can say answer my question. Yes or
no,
no? First.
no. Listen to me. You should be aware that there's a process, and every process was followed for the associate professor and for the professor. So the letter that you're talking about, did I write a letter? Did I issue a letter? Go to personnel if you have a problem with letter.
All right, thank you. I believe with all that, we come to the conclusion of the cross-examinations by you.
My lord, I have not concluded though. I still have.
Well, your time, by a fraction of time.
Would you respect my lord? Let it be on, my lord, let it be on record.
The truth is that I've given you 1 hour.
That's correct.
No, my lord. My lord, if you give me 1 hour, my lord, with due respect, sir. If you have given me 1 hour, this one has taken more than 40 minutes of the 1 hour.
No, you started at 11:50. 11:50, and you're closing at 10:50. So thank you. There must be an end to litigation.
I want to believe my lord to give me more time. I've not finished my questions, my lord.
No. What are the kind of questions you have left?
My lord, serious questions that will bring out the facts of it showed that my lord, he was not supposed to be. What was done was invalid.
Like what kind of question? Okay, one question. One.
As my lord pleases.
One last one.
No, my lord, not one last one. Let me ask this one. Apart from the letter of temporary appointments.
Yes.
There was no other letter of appointment. There was no other letter of appointment given to you in Michael Apara University. Apart from that first letter which you were appointed, given temporary appointment. Other letters were confirmation. No, there was no other appointment letter given to you.
My lord, this is one. This is letter appointing me as the senior lecturer.
Hold on. The letter of appointment as senior lecturer, dated 7/1/2013.
Signed by Wukocha, the registrar.
By the registrar then, yes.
Another letter of confirmation of appointment to the rank of associate professor signed by the vice chancellor.
Confirmation of appointment as
associate professor.
Was signed by
Professor Hilary Idoga.
Professor Hilary Idoga.
On September 8th.
8 September 2014, yes. Another one.
Then another letter of appointment. It's a confirmation of appointment to the rank of a professor of computer science.
Now he's taking more time, my lord. See how much time he's taking to answer the question.
Yeah,
he's taking more time than myself asking the my lord. He's not answering my question.
So what's the other one that you mentioned?
The question.
Another one of appointment dated
October 14, 2015.
14th October 2015.
As professor of.
From associate prof to prof.
Yes.
All right. These are all appointment letters. Is that what you're saying?
Yeah, that is correct.
Yes, thank you. You have done well. Mr. Okay, good. There must be an end to litigation.
My Lord, I have not finished. My Lord, let it be on record that
I am satisfied. I am satisfied. I've given you more than sufficient opportunity.
My Lord, see how much time it takes to answer questions. I have questions to ask you. Let it be on record. I want let it be on record with respect. I was foreclosed. Let it be on record.
Okay. Okay. Let me. You want me to write?
Listen, let it be on record.
Defender Counsel. What's your question? What's your application? That
my Lord, let it be on. I'm applying, my Lord, that
the court has not given me
sufficient time to ask my questions.
Not giving me sufficient time.
I was given only 40 minutes, and the witness took more than
to cross-examine this witness. So your query is that? My query is, yes, I'm writing you.
I don't have any query. Let just be on record that I wasn't given sufficient time, my Lord.
I was not given sufficient time.
Yes, my Lord.
All right.
To ask all the questions.
The counsel began cross-examination. I have to write a ruling. This witness at exactly 10:50 a.m.
No, my Lord.
The court, well, my record says 10:50. Stopped him at, what's the time? 10
minutes to 12.
11:54 a.m. That is about 1 full hour. Meanwhile, our rules of court specify 45, not more than 45 minutes, not more than. That's the time period to be given. I do not know if the defendant's counsel wants the entire time in the world. Well, but there must be an end to litigation. The game is now stopped, whether or not the defendant's counsel is satisfied. With the allocatable time. His objection is therefore disregarded. All right. Now you may get my ruling and appeal interlocutorily to the Court of Appeal that you are not given time. I've done that now. Can you also use this video as full evidence because it's recorded? You get it. Take you to the Court of Appeal and tell them that I did not give you sufficient time. I think I've done my best. But as far as the game is concerned, there's a time for everything, like any other game. Football, basketball. All right. So that is the end for the claimant's counsel, defendant's counsel with this witness. Yes, what's your next application, claimant?
My Lord, actually, I ought to have the ask for re-examination.
Re-examination, okay. All right. Do you have any questions?
But unfortunately, I didn't follow the proceedings because of network.
Don't tell me that. You don't have any questions. You don't have any questions?
My Lord, I don't have up to the point I follow the proceedings.
There's nothing. There's nothing. There's nothing. Nothing new was said. And there's no ambiguity. So you have any re-examination, you can do it now. Otherwise, I'll close you. Yes.
My Lord, as I said, up to the point when I followed the proceedings.
Well,
I didn't have any. Yes, sir.
I will
But
have
due
to
network issues. I wasn't.
No, you can't use that as an excuse. The claimant counsel, what you are saying is that I did not hear. Let me have you written too. Let me have your application written.
My Lord, my application,
Yes.
Yes, my Lord. My Lord, I said that I didn't follow the entire proceedings due to network.
Due to network interruptions.
Yes, sir.
So.
And that up to the point I followed and I had the proceedings. Yes, sir. I don't have any re-examination.
Yes. I did not for re-examination. Yes?
Yes, sir. Up to the point I followed.
So I take it that you don't have any questions.
There is none, my Lord.
Huh?
I don't have any questions on re-examination.
So re-examination.
What I've said. Yes, sir.
Thank you.
My Lord,
now, yes, Clement?
Yes, my Lord. My Lord, we have a pending motion before you.
What kind of motion?
It's a motion ex parte to call for writ of summons on our next intended witness.
That's not how it's done. That's an abuse of process. We have a pending motion to call the next witness. Can it be ex parte?
My Lord, based on the rules, except if I didn't get it very well.
What does the rules say specifically?
Yes, my Lord.
Order
Yes,
17. It has to be ex parte.
My Lord, that is order 38. My Lord, order 38 through 18:5.
Okay. What does it say specifically?
The Lord, it says that any of the parties to an action or matter before the court may apply to the court by motion ex parte.
Okay.
Yes, sir. To issue a summons to bring a person before the court, either to be examined as a witness. Yes, sir.
All right.
Yes, sir.
We have a pending motion.
Order 38
through 18:5. Order 38 through 18 sub rule 5.
Yes. It is made ex parte. But since the other party is here, you can move your motion, and if he challenges it, he will say it orally.
The Lord is even supposed to respond to it. It's ex parte, my Lord. Based on the rules. Based on the rules, my Lord.
Yes. The fact that
for us to call our next witness.
Yes.
Yes, sir. I don't know why you should oppose it. If they want to also call an additional witness, they can do so. It's in the interest of justice. Yes, sir.
You oppose?
Yes,
Why?
my Lord. My Lord, the processes filed by the claimant in this suit.
Even
my Lord, I am not aware. I am not aware. The witness is seeks to call.
Professor Hilary Edeoga.
Yes, my Lord. Yes, my Lord.
Yes, my Lord. First of all, that witness is based. The call of that witness is based on his further reply, what we call further reply of the claimant. The process of court we call further reply of the claimant. My Lord, I am not aware that in the rules of this court there's any such process like further reply. There's no process.
Reply. Is it after he filed a reply?
After he has filed his
He
reply,
filed a further reply.
he said he filed a further reply without the leave of court. Instead of amending the reply, so he said he's filing for that. There
Is
is no
that
such
true?
process
Is that
by the rules of
true,
this court.
Clement? Did you file anything called a further reply after filing a reply? If you did so, we'll look at it when at the appropriate time, and we'll
Yes, my
decide
lord.
what the fate of the reply
Further
is.
reply.
Mr. Okay, can you hear me?
Yes, my lord, I'm hearing.
Well, your application for a witness, an extra witness, cannot be stopped. It's your right.
No, my lord, my lord, if you are my lord, that application is based on what he called further reply of the
It's his
claimant.
prerogative.
Yeah, as companies, and that is technically
My lord,
my lord.
All you need to do is
My lord, there is
raise
no-
these issues in your final address and let me know.
As companies.
My lord, there is no process of this court known as further
It's
reply.
all right. It's all right. We'll allow him to continue doing what he's doing. If what he's doing is without any legal support, of course, he will not succeed. In the long run, I'll discard whatever he brings before the court based on that document. So what's your problem? In fact, you have even showed him your angle of defense now. You should have kept quiet.
Yes, my lord, it's fair hearing. We have to bring everything to the fore. My lord, I'm not aware there's any process known as further reply.
So I have your record that I object because there is nothing in our rules,
Our law
in the rules or law
known as further reply.
in the law known as further reply.
Yes, my lord. And the evidence of that witness is part of that further reply.
Yes.
Well, my submission, my lord, is that that witness cannot testify because they have not been competently brought in.
As such, that witness cannot testify.
Yes, my lord.
Yes.
My lord, since my lord has said I may do further submissions during the address because that witness too, I don't feel he is competent to testify. But my lord, I will make further submissions in the address.
Yes. Yes. You want to reply?
My lord, yes, my lord.
I'm listening.
Yes, sir. My lord, this court has gone beyond technicalities.
Yes.
Secret to the rules of this honorable court.
Yes.
My lord, at most, that caption can be regarded as a misnomer.
Yes.
It cannot affect the substance of the document. It's just a caption he's attacking.
Yes.
My lord, further, this particular document is sequel to their amended statement of defense.
Yes.
My lord, we recall that after our claim, they filed a defense, and subsequently they now discarded their witnesses and whatever they filed and filed an amended statement of defense. By then, we had filed a reply. So this is just a misnomer that we captioned it wrongly. It is to additionally respond to their amended statement of defense. That's just the intention, my lord.
Yes.
So it's a mere technicality to now attack the heading. And my Lord, I so apply that it be so properly amended, secret to the rules of this honorable court.
No, I can't do that. You have to do the right thing when it's time.
As court, please.
All I'll do, I'll give you my ruling right now. The application was filed when?
It was filed on the 5th day of October. 5/10/2021. 2021, my Lord. That's correct.
But there's no application. We just filed a process. There's no application.
It's an ex parte. It's here.
It's a nice party. The motion was filed on that date.
Before me, I can see it here.
Yes, sir.
Well, I think you have moved your application, haven't you?
My Lord, I don't know if my Lord has taken it as such, but it's just to enable us to call the next witness in the interest of justice, my Lord.
Well,
so that the court will get the true picture of this. And this particular man is the man who was at the helm of affairs when all these things happened. Yes, sir.
Let me give my ruling. This is an application that can be made ex parte, as rightly stated under Order 38 Rule 18, sub 5. Therefore, his application to call a witness is not precluded, as he has a right to be heard pursuant to Section 36, CFRA 1999. The fact that the witness deposition is tied to what the claimant filed as a further reply still does not fetter the claimant from producing whatever witness or evidence he wishes to rely on at trial. Consequently, the application of 5/10/2021 is hereby allowed.
As court, please.
You know what to do. If his deposition is not properly filed, we'll throw this thing outside. That's your own cup of tea. All right. There's, just like he said, there's nothing like a further.
As court, please.
Want to amend, you know what to do.
As court, please.
Right. So when are you calling him?
No, that will be on the next adjourned date. I don't know when we are coming back.
Yes, date. 23rd February 2022. For continuation of hearing.
My Lord, just 1 minute, my Lord. My Lord, I'll prefer, if my Lord, I'll please my Lord to give us the next week. We're already there on 2 occasions in that week, within that week.
25th December 2021.
But I plead that we'll be given 1st of March.
1st March?
Yes, my Lord.
1st March 2022 for continuation of hearing.
Hello, we are grateful. Thank you, my Lord.
Good luck. I wish you happy holiday.
Thank you, my Lord.
Same to you, my Lord.
I shall rise.
For employees. Yeah, God for employees.
It's not true. It's not true. Let the employers do the right thing. Emma, what date was that?
1st March.
Emma? Okay, 1st. Okay.
1st March.
Okay, 1st.
Ibrahim.